Now you confused me. Good morning, Ms. Selina.
Apologies. As I've previously indicated, Chair, I'm a creature of instruction, so when I'm instructed to move, I move.
Oh, and good morning, Ms. Maya.
Good morning, Chair.
Thank you. And I don't know whether to say advocate. You say you were appointed as an advocate upon joining IDAC, I think you say in your statement. But with regard to admission, I saw no admission other than your admission as an attorney. So it may be a technical issue, but it exercised my mind. So I don't know whether to refer to you as Advocate Ramsamy if you were never admitted as an advocate.
Morning, Chair.
Good morning.
Chair, I'm an admitted attorney.
Yes.
State advocate is the title that is given to a prosecutor upon promotion. So Ms. Ramsamy or Drew is fine.
And you are perfectly fine with it?
Yes.
All right. Good morning, Ms. Ramsamy. Thank you very much. Let me just, before we start, say something. We received the statement, I think, in the evening yesterday, I think.
Yes, Chair. Perhaps before you make any remarks regarding the statement, may I address the commissioners?
Yes.
Because I have got a request to make.
Yes.
As the commissioners are well aware, as we were leading the evidence of Advocate Johnson, some of my colleagues were attending to other matters, including this particular witness.
Yes.
Now, the administration hasn't quite caught up, I think, with us.
Yes.
So even the witness doesn't have a statement, so we can't start. I was going to ask for a stand down to allow copies to be made and at least avail to the witness to enable the proceedings to start.
I thought the one we got was the electronic version. Aren't we able to start perhaps using that electronic version so that we try to save time?
It's clarified for me, Chair.
I'm actually being shown a hard copy in front of me.
Yes, though the witness may have an electronic version of her own statement,
yes,
she has got significant annexures, and it's the production of those files that seems to have been delayed.
Yes.
Advocate Sigals-Ngube would, if she had her way, her preference would be to start with the annexures immediately available for the witness, but we are not currently in that position. I'm not in a position to indicate how long a stand down would be required.
All right, then we'll stand down. But let me. That's your preference. Good morning, Ms. Sigals. Is that your preference?
Yes, Chair. That is the preference, and Mrs. preference as well.
Oh, all right, all right. Let me raise the point or the issue I wanted to raise. Having gone through the electronic version of the statement, which, as I say, we received in the evening yesterday, I noticed, and this must be true of my colleagues as well, that the statement implicates Advocate Johnson quite seriously. What I wanted to raise, I do have thoughts of my own as to why what I'm going to raise did not happen. My mind is focusing, for example, on the fact that what Advocate Johnson is implicated on was not put to her. I can imagine why not, but I would like you to please comment on that, Ms. Sigals and Ms. Sigals and perhaps also address us on how, in practical terms, this is going to be addressed so as to treat Advocate Johnson fairly.
Thank you, Chair. Chair, the position is that on the 22nd of July, when Advocate Johnson gave evidence regarding certain events that occurred in the Mokwele investigation, she mentioned the name of Mrs. Ramsamy. And during that evidence, I received personally, because I was assisting Advocate Selo, I received a message from a DPCI officer who had indicated to me that Ms. Ramsamy had made certain disclosures to him regarding these matters and had wanted to consult on the matters. That is why I excused myself from those proceedings and discussed it with the NPA, and we arranged a consultation with Ms. Ramsamy for the 22nd of July while Advocate Johnson was giving her evidence. So we first became aware of these allegations against her during her evidence, and the witness was very clear that she had wanted to give evidence in public. She was aware of the allegations that she was making, that they were serious, but had not wanted them to be put to Advocate Johnson until she had been given an opportunity to give her full version, because her intention was in any event to only make this disclosure under protected disclosure protection after Advocate Johnson gave her evidence. But given that Advocate Johnson had implicated her in these proceedings, she thought that the correct process to follow would be to come to us with that evidence. So we did not have this information prior to Advocate Johnson giving her evidence. It only became known to us during her evidence. The intention is to serve a Rule 3 notice on Advocate Johnson to address these allegations, Chair. And that will be done during the course of today and tomorrow, depending on whether there are further matters that emanate from her evidence. As Chair would notice from her statement, she wants to give evidence in 2 parts, and she's only submitted 1 statement thus far. There will be another statement which further implicates Advocate Johnson. So it is either that we'll serve the notice today in respect of this first statement, or we will wait until she concludes her evidence on both statements. Second statement not yet provided and concluded, and then we will furnish a full Rule 3 notice on Advocate Johnson.
It was finalized only yesterday.
The first statement,
which was Advocate Johnson's last day of testimony.
Correct, Chair. This last night is when the statement was finalized at shortly after 6. And it was signed, she signed it this morning. The statement.
Oh, I did not even notice that what I read was not signed.
Yes, Chair.
Yes,
it was an unsigned version yesterday, and she signed this morning. The statement.
Oh, thank you. We'll take the adjournment then, and we'll hear from you when we should come back. Thank you,
Chair.
Thank you, Chair.
To testify about. I have to set the record straight at the onset regarding Advocate Andrea Johnson's testimony before the Commission. Advocate Johnson told many untruths about me and my involvement in what is now known as the Mokwele case. She did not disclose that I raised concerns from the onset and repeatedly thereafter, which concerns I deal with in detail. These concerns are not limited to the Mokwele matter. I had concerns about the crime intelligence-related cases and matters relating to the National Commissioner, General Fani Masiamola. Advocate Johnson decided shortly after the Section 2813 authorization of the crime intelligence matters that all other crime intelligence matters would be ring-fenced into a project which she named Project Diversion. I do not know why she chose this name, other than that what is stated in the WhatsApps that I have provided.
Which we will get to in the chronology of events.
Correct.
Okay, the next page, paragraph 5.
Thank you. I am profoundly disturbed but not surprised by Advocate Johnson's testimony. She sought to blame me for so-called irregular or problematic processes. Let me make it clear that Advocate Johnson was in charge of Project Diversion, and in particular the Mokwele matter from the onset. I deal later with the makeup of the team, which was different to how a project or investigation team is usually constituted. It is my belief that Advocate Johnson handpicked me to be part of this project because I had successfully, or rather we had successfully investigated another Section 27 referral matter involving a high-profile individual. I also believe that Advocate Johnson picked me because she thought that I would not question or ask questions because I'm a state advocate, not a senior state advocate, not a deputy director of public prosecutions. What she did not anticipate was that Mr. Mansa Rapesu, the lead investigator, and I would question project diversion from the start. May I proceed? Thank you.
Continue.
Thank you. I confirm that I prepared documents on Advocate Johnson's instructions that instructions that were one, not in accordance with IDAC standard operating procedures, which Advocate Johnson indicated to this commission did not exist. 2, the process followed in July 2023 referral. And 3, that went against my concerns when assessing the merits of the complaints by Mr. Adams. I refer in particular to the application for authorization of Section 2813 investigation that I prepared on the 5th of December 2024.
Sorry, can I just interject there to deal with the issue of the standard operating procedure, which you deal with in that paragraph, which you say Advocate Johnson said does not exist. If we could ask the commissioners to go to file 10 and page 9, which is, if you can identify that document for us, and the signature on page 10.
Page 9 is the Investigating Directorate Against Corruption Operations Manual. This is disseminated via email to every person that works at IDAC. It is also re-disseminated to every staff member upon the arrival of a new staff member. So it cannot be said that there are no operating procedures or SOPs within IDAC. Page 10.
Page 10, it should be page 10. You were on 9, which was the first page of the operation, and then page 10.
The last paragraph or portion of that page 10 is the signature of Mr. Matthew Sissoko. He is the head of investigations and operations, also known as the second in charge of our office. And then thereafter is the signature of Advocate A. Johnson, Investigating Director IDAC. Please note that the dates also indicate 16 October 2024. This is version 2.
Yes, we can see there that version 1 is 18 December 2023, and then version 2, 16 October 2024.
Correct.
And could you just briefly tell us what the operations manual deals with? We are going to deal with it in detail later when we engage you on the processes, but if you could just give us a high-level summary of the document for now.
The operational manual.
Sorry, Ms.
Am I speaking
Ramsamy.
too
Yes,
softly?
and
I apologize.
closer.
Okay.
Yes.
The operational manual is supposed to, and I use the word very, supposed to, create structures in which the IDAC works. These structures are based in terms of Section 7 and 27, 28, and 29 of the NPA Act. It sets out procedures with regards to investigations, referrals from the NDPP, team constitutions, reporting lines, presentations, instructions on how presentations are supposed to be done, on briefings as and when investigations are in progress. Basically, it's the Bible. of how a structure of our nature is, or IDAC's nature is supposed to work. And when I use the word supposedly, if I may, Advocate Segal, continue. Thank you. Advocate Johnson would deviate constantly. It was a situation where we had this, but she would also have her own way of doing things with different groups, different investigations, different structures. So there was a constant deviation from what was in black and white. And it was always from her office that the deviation was done. And when the deviation was done, it always came with intimidation.
Can you explain intimidation in this context?
Am I allowed to say it as we say it in the office?
Yes, please.
The nickname for Advocate Johnson in the office is flip-flop, knee-jerk.
Okay, just explain that.
You would get instructions in the morning. Can I speak from my personal experience now? Okay.
Yes, please.
You would get instructions, or you would have a conversation with Advocate Johnson in the morning, or telephonically, or via WhatsApp. And it would be just the two of you, or maybe another prosecutor and you. And you would find commonality, or you would explain the legalities, the processes. I mean, the elements of an offense changes, but the principles of law does not change. If you have a document in a murder matter, it doesn't change when you're trying to prove it in a corruption matter. So you would have those engagements with her. And then during the course of the day, there would be a conversation that would take place between Mr. Perumal and Dylan Perumal and Advocate Johnson. And the flip-flop would happen. So no matter how you explained it to her, or how the decision was made in a rational manner, it would then change according to what Mr. Perumal wanted. And my evidence will show how that affected the investigations.
And when you were engaging Advocate Johnson with...
Page 10.
Page 10, it should be page 10. You were on 9, which was the first page of the operation, and then page 10.
The last paragraph or portion of that page 10 is the signature of Mr. Matthew Sissoko. He is the head of investigations and operations, also known as the second in charge of our office. And then thereafter is the signature of Advocate A. Johnson, investigating director IDAC. Please note that the dates also indicate 16 October 2024. This is version 2.
Yes, we can see there that version 1 is 18 December 2023, and then version 2, 16 October 2024.
Correct.
And could you just briefly tell us what the operations manual deals with? We are going to deal with it in detail later when we engage you on the processes, but if you could just give us a high-level summary of the document for now.
The operational manual.
Sorry, Ms.
Am I speaking
Ramsamy.
too
Yes,
softly?
and
I apologize.
closer.
Okay.
Yes.
The operational manual is supposed to, and I use the word very, supposed to, create structures in which the IDAC works. These structures are based in terms of Section 7 and 27, 28, and 29 of the NPA Act. It sets out procedures with regards to investigations, referrals from the NDPP, team constitutions, reporting lines, presentations, instructions on how presentations are supposed to be done, on briefings as and when investigations are in progress. Basically, it's the Bible of how a structure of our nature is, or IDAC's nature is supposed to work. And when I use the word supposedly, if I may, Advocate Segal, continue, thank you. Advocate Johnson would deviate constantly. It was a situation where we had this, but she would also have her own way of doing things with different groups, different investigations, different structures. So there was a constant deviation from what was in black and white. And it was always from her office that the deviation was done. And when the deviation was done, it always came with intimidation.
Can you explain intimidation in this context?
Am I allowed to say it as we say it in the office?
Yes, please.
The nickname for Advocate Johnson in the office is flip-flop, knee-jerk.
Okay, just explain that.
You would get instructions in the morning. Can I speak from my personal experience now? Okay.
Yes, please.
You would get instructions, or you would have a conversation with Advocate Johnson in the morning, or telephonically, or via WhatsApp. And it would be just the two of you, or maybe another prosecutor and you. And you would find commonality, or you would explain the legalities, the processes. I mean, the elements of an offense changes, but the principles of law does not change. If you have a document in a murder matter, it doesn't change when you're trying to prove it in a corruption matter. So you would have those engagements with her. And then during the course of the day, there would be a conversation that would take place between Mr. Perumal and Dylan Perumal and Advocate Johnson. And the flip-flop would happen. So no matter how you explained it to her, or how the decision was made in a rational manner, it would then change according to what Mr. Perumal wanted. And my evidence will show how that affected the investigations.
And when you were engaging Advocate Johnson, what did not sit well with me?
Page 3.
Yes, page 3, paragraph 6. You'll see after you deal with the 3 points, you then say, I refer in particular to the application for authorization. Do you have that?
Yes.
You can read from there.
I refer in particular to the application for authorization of a Section 2813 investigation that I prepared on the 5th of December 2024. I will explain why this did not sit well with me. However, the commissioners must bear in mind that at this point, Advocate Johnson had stated they had made a decision that the matter was to proceed in terms of Section 2813, and that I was to draft the authorization and email it to her on the same day that the referral was handed to me, because she wanted to approve it by Friday, the 6th of December 2024. I deal with this fully later in the statement.
Continue.
On or about the 30th of June 2025, after the Mokwela arrest and the first appearance, I contacted a DPCI officer. I must state I trust this DPCI officer, which is why I contacted him, to inform him that there's a problem at IDAC and that I need to see him and explain and show him the documentation that I had in my possession. I asked if I could do protected disclosure We agreed to meet on the 2nd of July 2025, where I showed him a prosecutorial memo prepared by me and another prosecutor regarding the matter of General Masiamula and Lieutenant General Kumalo, which I deal with later. He said that he would speak to a colonel at the DPCI and get back to me as to how we were to proceed. The reason that I contacted DPCI is because I had previously, in late April 2025, informed Advocate Santos Manilo, the DDPP that I report to, of the discord amongst the team being that of the crime intelligence investigation, and that the investigation procedures were being flouted and that the investigation was sloppy. He replied that he had his own problems. In August 2025, I started collating documents regarding what I considered to be unlawful instructions from Advocate Johnson and Mr. Perumal regarding project diversion. May I proceed?
Ms. Ramsamy, sorry. When Advocate Manilal says he has his own problems, was it about the same issue, the crime intelligence investigation, or?
He had not, although he was on paper as the deputy director, he had not been briefed on the matter, which I do discuss later on in the statement.
The question I'm asking is, when he said he has his own problems, did you understand him to mean about the same subject, the same investigation, or he had his own problems within IDAC? I'm just trying to understand what it is he was.
I understood it to mean that he was not interested in my problems and this project.
I see. Yes, thank you. That answers me. Thank you.
Okay, continue.
On the 8th of August 2025, Advocate Peter Surunye, a deputy director of public prosecution, came on board the Mokwele and Lushaba cases. He started sending emails and memoranda that accorded with my concerns on how the Mokwele matter was being conducted. Advocate Joyshla Swayo and I also approached Advocate Surunye with our concerns. He can confirm this to the Commission. When Advocate Surunye requested to be removed from the Mokwele and Lushaba cases, I was removed from the Mokwele case, and although I was apparently kept on the Lushaba case, I was excluded from the case from September 2025. I also approached another deputy director and showed him all the documentation that were concerning. He stated, "These things will never come to light." In November 2025, after Advocate Johnson testified at the IDAC committee, I contacted the same officer at the DPCI. I informed him that Advocate Johnson had lied to the IDAC committee and that I had proof of this. Once the new NDPP, Advocate Matibi, was appointed, I met with the DPCI officer. This would have been around March 2026.
Can I just interject to ask you why it's significant that you mention once the new NDPP was appointed? Did you meet with the DPCI officer?
Because I knew that if I had reported or we had taken these concerns to this then sitting NDPP, nothing would have been done. Advocate Johnson, there would be no repercussions, there would be no corrective measures.
By that you mean Advocate Shamila Batoy?
Correct.
Why would you form that opinion?
I was aware of the matter that was discussed with the Commission about the sharing of documents. But that was corridor talk, so I wasn't confirmed. But if I may put it frankly, from a prosecutor's point of view that's in the office every day, Advocate Johnson was the blue-eyed girl of Advocate Batoy. She could do no wrong. If needs be, or if the Commission so sees fit, if you look at any grievance that was sent about IDAC, from the staff members, it was squashed to an extent where people started just resigning. People were applying for posts I'm an SA. I've been applying for SA posts just to get out of that unit.
And you refer to the sharing of documents, even if in section 28 itself there may be no specific provisions, the Constitution is an overarching document. So section 28 would still have to be applied with the Constitution or the privacy right in mind, if you see what I mean.
Correct. And
yes.
My evidence, not very far down the pages, does deal with how this is so severely abused and how it continued since my start at the ID to be sorry, advocates.
That's fine.
Still on this, on the operations manual, the impression, I don't know if it's just me, but the impression from advocate that I gained from Advocate Johnson's evidence about this, the existence and application of an operations manual, was that yes, there is such a document, but we don't operate according to it. So the impression I had was, it's sitting somewhere in a computer or on your mainframe, but in fact, it's more, you just go about doing your things and people exercise their discretion at any one time in meetings without this ever being applied. Is that correct? Because you speak of it as a deviation in your testimony. You say she deviated from what this prescribed. Is that deviation as a matter of course? That's what happened, and therefore this was just good on paper for all intents and purposes.
It's applied as and when Advocate Johnson wanted to use it.
All right, I'm answered. Thank you.
Okay, we can go back to your statement, paragraph 6.
I understood it to mean that he was not interested in my problems and this project.
I see. Yes, thank you. That answers me. Thank you.
Okay, continue.
On the 8th of August 2025, Advocate Peter Serunier, a Deputy Director of Public Prosecution, came on board the Mokwele and Lushaba cases. He started sending emails and memoranda that accorded with my concerns on how the Mokwele matter was being conducted. Advocate Joyce Swayo and I also approached Advocate Serunier with our concerns. He can confirm this to the Commission. When Advocate Serunier requested to be removed from the Mokwele and Lushaba cases, I was removed from the Mokwele case, and although I was apparently kept on the Lushaba case, I was excluded from the case from September 2025. I also approached another deputy director and showed him all the documentation that were concerning. He stated, these things will never come to light. In November 2025, after Advocate Johnson testified at the IDAC committee, I contacted the same officer at the DPCI. I informed him that Advocate Johnson had lied to the IDAC committee and that I had proof of this. Once the new NDPP, Advocate Matibi, was appointed, I met with the DPCI officer. This would have been around March 2026.
Can I just interject to ask you why it's significant that you mention once the new NDPP was appointed? Did you meet with the DPCI officer?
Because I knew that if I had reported or we had taken these concerns to this then sitting NDPP, nothing would have been done. Advocate Johnson, there would be no repercussions, there would be no corrective measures.
By that you mean Advocate Shamila Batoy?
Correct.
Why would you form that opinion?
I was aware of the matter that was discussed with the Commission about the sharing of documents. But that was corridor talk, so I wasn't confirmed. But if I may put it frankly, from a prosecutor's point of view that's in the office every day, Advocate Johnson was the blue-eyed girl of Advocate Batoy. She could do no wrong. If needs be, or if the commission so sees fit, if you look at any grievance that was sent about IDAC from the staff members, it was squashed to an extent where people started just resigning. People were applying for posts. I'm an SA. I've been applying for SA posts just to get out of that unit.
And you referred to the sharing of documents.
Ms. Ramsamy, you refer to Advocate Johnson as Mama. Why is that? You can switch on your mic.
When I started with ID, before it became IDAC, Advocate Johnson was the head of office. We had a choice between calling her ID or Mama J. And I respectfully call her that because she's not a bad person. She's not. She's, when I got sick, she was there. She was she's kind. It's just the work ethic that I have a problem with. And so I respectfully call her Mama.
Okay. So
I just got the J part out.
Okay, this was the recording on the 22nd of July where you telling her how those names came about.
Correct.
And you are referencing emails that were sent in December 2024 where Mr. Perumal indicated that he had consulted with Mr. Adams.
Correct.
And those emails you have provided to us, we'll get to that. But if I understand it, the emails you are referring to in that recording are emails that were sent after, in response to your docket report.
Correct.
Okay, which comes after the dockets were collected and after the 2813 is authorized.
Correct.
Okay. So we should then go back into your statement to deal with the 2813 investigation, which is on page 21 at paragraph 49.
Mr. Rapesu?
No, page 21, paragraph 49. 2813 investigation.
Returning to the events of December 2024, on the 6th of December 2024, before the staff meeting, I went to Mr. Rapesu, who had been designated as one of the investigators in the Adams referral. I trusted Mr. Rapesu. I had to show him the affidavit because I had such unease about what I was instructed to do, especially given the lack of substantiation of the allegations contained in this Section 27 referral affidavit, and the fact that I had been given names of suspects to include in the Section 2813 application, that I simply couldn't reconcile with the contents of the Section 27 referral affidavit. Paragraph 50. Mr. Rapesu briefly perused the affidavit before I had to return it to Advocate Johnson shortly before the staff meeting. I went to Advocate Johnson's office and returned the Section 27 referral affidavit, and she gave me the signed 2813 authorization. There was a meeting scheduled for 11 a.m. with the team assigned to the Adams referral, which took place in Advocate Johnson's office. Present in the meeting was Advocate Johnson, Mr. Perumal, Mr. Rapesu, Mr. Padiachi and Vessels were not present, and I. Mr. Padiachi and Mr. Vessels were not present in this meeting. Before I deal with the events that transpired from the 6th of December 2024, I want to make it clear that Advocate Johnson and Mr. Perumal launched an orchestrated attack on General Masiamula and General Kumalo, using IDAC's powerful investigation tools. And this will become evident in my statement and testimony. 4. She did not explain the urgency. I requested that I be allowed to draft the application when I got home later that day, because I had to be in High Court in the morning for another matter. She said it was fine as long as she received it that evening. I assumed that when Advocate Johnson stated they decided, that there will be an investigation, that she had already received a consideration of mandate memo from a senior prosecutor, DDPP, as this was done in the other section 27 referral matter. The matter immediately did not sit well with me. In my limited experience, the prosecutors who prepared the consideration of mandate memo ought to be the prosecutors preparing the application for section 2813. Investigation authorization. But since the instruction came directly from Advocate Johnson, and she had already told me that the decision had been made and that she wanted to approve the section 2813 the next day, I complied with her instructions. Later that afternoon, I went about preparing the application. When I read the section 27 affidavit that Advocate Johnson gave me, I became very concerned about the merits of the application. I have to deviate before I deal with the application itself. To deal with the contents of the Section 27 referral affidavit that I received from Advocate Johnson on the 25th of December 2024. Sorry, 5th of December 2024.
Okay, then the subtopic, the Section 27 referral affidavit.
When Mr. Padiachi testified before the commission, a document was flighted, and it was identified as the Section 27 referral affidavit of Mr. Fadil Adams. This document is contained at page 512 to 516 of the IDAC exhibit bundle. When I saw this document, my heart dropped to my stomach, because this was not the 27 referral affidavit that Advocate Johnson gave me on the 5th of December 2024. In fact, I saw this document for the first time when it was flighted at the commission. I initially thought I was mistaken. I then contacted Mr. Rapeso to discuss with him. He confirmed that the Section 27 affidavit that was flighted at the commission was not the Section 27 affidavit I had shown him on the morning of the 6th of December 2024. I will return to why I showed the Section 27 affidavit to Mr. Rapeso in violation of Advocate Johnson's instructions not to show the affidavit to anyone. I have not seen the Section 27 affidavit after the 6th of December 2024. After I had returned it to Advocate Johnson. What I recall of its contents is based on my memory, but as the Commission will see, there are certain contemporaneous recordials by me that somewhat corroborate my recollection of the contents of the Section 27 affidavit. For convenience, I will deal with the Section 27 affidavit that I was given on the 5th of December 2024 compared to the Section 27 affidavit that was flighted before the Commission in tabular form. Page 16.
So what we then have is a table with, on the left, the Section 27 affidavit that was given to you on the 5th of December versus on the right, the Section 27 affidavit that was flighted at the Commission, which is 512 to 516 of File 2 of the exhibit bundle.
Correct.
So at number 1, you can start there.
Thank you. The Section 27 affidavit seen on the 5th of December 2024 referred to Orlando Cass. I am not going to read it into the record, and a Valeria Cass. The Section 27 affidavit flighted at the Commission, page 512 to 516, listed Cape Town Cass dockets. 2. Major General Modondo failing a polygraph test while seeking security clearance. Although...
Maybe for the record, you're unfortunately going to have to repeat the heading.
Okay, not a problem.
I think you can just say the section affidavit you saw, then say that is what it contained, and then say the flighted one, this is what.
Noted. The one that I saw, Major General Modondo failing a polygraph test while seeking security clearance, was prominent or noted On the one that was flighted, although vetting is mentioned, it is in a different context and no mention is made of a polygraph test. The one that I had seen, number 3, allegations of procurement irregularities within crime intelligence regarding the procurement of a forklift. On the one flighted, there's no mention of a forklift. Number 4, on the one that I had seen, multiple allegations of alleged criminal conduct by the political killings task team, such as procurement of vehicles, excessive budget for laundry using the Secret Service account. This is not mentioned on the 27 flighted. Number 5, vehicles that were procured for the PKTT being used by the former Minister of Police, Mr. Cele, for his personal use. This is also not on the one that is flighted. Number 6, purchasing of hotels, lodges, or properties using the Secret Service account, also not mentioned on the one flighted.
Okay. Paragraph 37.
The commissioners will hear from Mr. Rapeso as to his recollection of the contents of the Section 27 affidavit that I showed.
Included that we've been lied to, but I'm just saying perhaps the lied to is an appropriate, stronger word in the context.
I'm trying to be polite.
Thank you. May I ask you to read the last sentence of paragraph 5? You did not read the have, if I'm not mistaken. And
Paragraph 5 in the...
45, the last sentence starting if she.
Thank you. If she disagreed with the contents of my email, she would surely have responded either directly to the email or via WhatsApp.
Okay, we're just trying to locate the WhatsApp screenshot. I know that it had been provided to us where Advocate Johnson responds, and it should be in the exhibit bundle, but for some reason it's not in the electronic version, but we'll come back to it later. But we have seen it. Can we then go to the next topic, subtopic, explanation of the names of suspects in the Section 2813 authorization?
Paragraph 46. Another issue that warrants special mention is the issue raised by the Commission about the lack of substantiation of the names of the suspects listed in the Section 2813 authorization. As indicated when Advocate Johnson instructed me to prepare the application for the Section 2813 authorization, she gave me a list of suspects' names on the pink purple notepad page. This has consistently been my version. Paragraph 47. On the 22nd of July, 2026.
It's the 22nd, yes, so there's a correction. Yes. The statement says 21, but it was 22.
The Commission asked Advocate Johnson to explain the source relied upon for the names that appeared in the suspects on the Section 2813 authorization. As stated earlier, I got the names from Advocate Johnson together with the Section 27 referral affidavit. Advocate Johnson undertook to make inquiries. Later that day, at approximately 3:10, while I was consulting with the Commission's evidence leader, Advocate Johnson called me. And the call was recorded. The Commission is in possession of the recording because Advocate Johnson had already scapegoated me in her testimony before the Commission. And I felt I needed to record our conversation. In the recording, I explained how the names ended up in the Section 2813 authorization based on the names she gave me. At the stage of the recording...
At the start of the recording,
Advocate Johnson made a startling remark that we gotta figure out how you don't go. In other words, find a way for me not to testify before the Commission. I have no objection to the recording being played.
Chair, Commissioners, at this stage, we want to play that recording for you. It is approximately 12 minutes. We have tried to only deal with what we consider to be important, but actually all of it is important. And there may be a point that we do cut it where it has nothing to do with the subject matter. It deals with three aspects. Number one, what the witness had just indicated now, a comment that they must find a way not for her to testify before the commission. The second,
her being
the witness before you now. The second issue is a debate or an exchange about the names, how the names came about in the 2813. And then there is some criticism that Advocate Johnson makes towards the commission and the process that the commission is following, which we don't think is relevant, but it may be that we have to play the entire recording so that it's not suggested that we are withholding anything insofar as the recording is concerned, Chair.
And I believe that all three of us have very thick skins.
I believe so too, Chair. Thank you. So if you just indulge us, we'll be listening to it for the next 10 to 12 minutes.
Advocate Johnson testified that we sent the letter requesting the dockets to Major General Khumalo, and that he had indicated that the dockets were not with him or were not his. As stated above, the letter was never sent to Major General Khumalo, and Advocate Johnson knew that because she told me to shed the letter. Advocate Johnson told me that the letter had been changed and addressed to General Central.
Sorry, I may have misunderstood. Was the one that you had to shred, not the one that was to go to Lieutenant General Jacobs?
No, Chair.
All you have at this stage are the dockets and the Section 27. How do the two of you know that General Lushaba banks with Bank A and that it is Bank A that you must subpoena for his bank statements? Where does all that information come from? Because if it was a subpoena to SAPS, everybody knows that a general is employed by SAPS. But once you issue a subpoena to a bank, it means you must know that Khumalo banks with that bank, and that's the person we must issue a subpoena to. Because this is still the 11th of December. There's a weekend on the 7th and the 8th, the dockets only came in on Friday. So 2 days later, and this information is not in the dockets. What's going on here?
It was another pink note on another piece of paper.
It was on the pink note.
On another piece of paper.
Another one, not the original one.
With handwriting. And then with regards to the register, Mr. Perumal told me it will be futile because of how many people sign in and out. So yes, I did draw the same conclusion as the Commissioner, that this could not have happened.
I mean, if somebody left classified documents on my desk and I happen to open the envelope and I see that they are there and I report the matter to IDAC, why would you charge me for that? Because I found them there. It's not as if, I acquired them through some improper means.
Commissioner, we must look at the timelines. And that is what I questioned about. I questioned, you received in September under your door. You opened your cases at the end of October. You refer to IDAC middle end of November. That's a very long time to be in possession of those documents.
It means he had them with him for at least 2 months before he came to IDAC.
Correct. The other concern is that when you were opening the dockets, if you didn't want to give the original of the documents that was slotted under your door, why not make copies, have them certify it, and attach it to the A1? in the dockets.
He kept them with him even after the Section 27 referral to IDAC. He did not give them to IDAC.
Yes, well, the information that was relayed to me directly by Mr. Adams and confirmed by Mr. Perumal, and it is in the recording that I have provided. It's just a very lengthy recording. I recorded the entire consultation with Mr. Adams. When I start asking Mr. Adams, we had the documents. He said, no, I kept copies, but I'd given the documents to Dylan. And Dylan confirms, yes, no, we have them.
And it's Perumal.
Perumal.
Thank you.
Thank you.